I now call to order the meeting of the Township of Morris Planning Board for Monday, March 3rd. The legal notice required in accordance with the Open Public Meetings Act has been satisfied, and a statement certifying same will be executed. Please join me for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Could you do the roll call, Sonia?
Mr. Alesso.
Here.
Mr. Order.
Here.
Mr. Nunn.
Here.
Mr. Babbitt.
Here.
Ms. Murphy.
Here.
Mr. Benoit.
Here.
Mr. Quillen.
Here.
Mr. Riglia.
Here.
Mr. Vaz.
Here.
Mr. Warner.
Here.
Mr. Phillips.
Here.
Mr. Hanson.
Here.
And I'm Sonia Santiago. Oh, Mr. Wallace.
Always have to look behind you, Sonia.
Yes.
Ed, your microphone on? Everyone's on?
I have nothing to say anyway.
Sure. Okay, we actually welcome back. We've missed another meeting or two, so it's nice to see everyone again. A number of things on the agenda tonight, but there may be some confusion over the role in some of the items on the agenda. So, Mr. Warner, you want to kind of explain the role of the public in this meeting?
Certainly, Mr. Chairman. We do have, but sometimes our board has master plan consistency reviews. Part of the process when ordinances are adopted that relate to land development. And quick primer, if I may, if you give me the floor, Mr. Chairman.
Yes,
I'll take it
yes,
for
yes,
a while.
I-
My apologies, but the governing body, our township committee, introduces, as it does in all municipalities, introduces ordinances. When they relate to land development, the planning board plays a role in, and it's a very narrow role, in reviewing the ordinance for master plan consistency. And generally, and certainly this evening, I anticipate the board will hear from our planner, Mr. Phillips, the best, and we'll hear whether or not, in his opinion, it's consistent with the master plan or not, and then the board will render a determination accordingly. Has virtually nothing, if nothing at all, to do with the substance and policy of the ordinance. It simply is a strict determination whether it's consistent or not with the master plan per the advice of our planner. It is not a public hearing. However, there is a public hearing in the process, as perhaps everyone knows, and that is that after the ordinance is introduced, which these four ordinances relating to tree removal, rezoning, site plan waivers, and certain cannabis zone being designated, those four ordinances will have a hearing on each and every one of those on second reading by the governing body. It's my understanding all four, at least presently, are slated for second read and public hearing on March 19th. Please correct me if I'm wrong. So that is the opportunity for the full public hearing for all members of the public to be heard on the ordinance, specifically with respect to policy, et cetera, the actual ordinance itself. This is very narrow, and it's just a planning determination made by the planner and usually followed by the planning board, and then it moves it on, if you will, to the next step. So to the extent people are here for any or all of those ordinances, you certainly can stay. This is an open public meeting, but I didn't want, and I know the board didn't want anyone to misconstrue and think that there was a public hearing on any or all of those ordinances, and that members of the public would be able to speak to their views on the ordinance. That happens on March 19th with respect to all of them. So as a courtesy, wanted to make sure nobody stayed any longer than they might otherwise want to. Everyone's welcome to stay all night long. As far as I'm concerned, I'm sure as far as the board's concerned.
May I ask for some clarification on that as a member of the public?
Otherwise, maybe I won't stay here tonight.
Yes, no, that's
name is
why we
Paul.
made the announcement now, because I
Yeah,
don't
thank
really
you.
want people to have to stay around if they
Very good.
don't get a chance to speak.
Thank you. I've not been to a planning board meeting in some time, so some clarification around this for myself and some other members here
Right.
might be helpful. Paul Stout, I live at 29 Oak Lane in Morris Township. So you're telling us that you're going to look at the master plan tonight. I'm speaking specifically to the cannabis applicant or matter. So if I have concerns about how the master plan is going to look at cannabis in this township, I wouldn't have an opportunity to question what you're discussing tonight or comment on that tonight, or one or the other?
It's not a public hearing, and the master plan, as it presently exists, and our planner can correct me if I'm wrong, but is what our planner will opine by. In other words, if somebody believes the master plan should change in the future, that's not within the jurisdiction of the board this evening. There's no master plan before the board. This is simply, here is an ordinance. It relates to land development. Ultimately, we'll get there. Mr. Phillips, in your opinion, is it consistent or inconsistent with the master plan, and why? He will advise the board, and then the board will most likely take his recommendation based on his opinion and find that it either is or is not consistent with the master plan. And then regardless of what the board finds in that regard, it moves to the governing body, having given this board that referral opportunity on that one narrow issue, and then a full-fledged public hearing on all aspects of the ordinance, including perhaps if one wishes to say, I think the master plan should change in the future in order to say this or that. Relative to that ordinance, I would think that would be relevant at that time for that public hearing. So there's a little, if any, limitation on what you can raise during the public hearing, but in the ordinance process pursuant to statute, the municipal land use law specifically, there is only one public hearing opportunity, and that is, and appropriately so, in front of the governing body, who will either adopt an ordinance or not, or amend it, or what have
So
you.
you're telling me then that a member of the public can't have any sort of influence for or against at this hearing tonight?
Because there is no hearing tonight, then generally, yes, that's correct. Because the only issue is the master plan consistency as the master plan presently exists in the view of the professional planner for the board, and then it's left to the board. But all things are fair game, if you will, that are relevant to any ordinance at the time of the public hearing before the governing body on second read, before anything is adopted, amended, or not adopted. Whatever the governing
Okay, so
body
we can stick
decides.
around and listen tonight, but no question or comment?
Generally, that is the process. Unless anybody changes that process, it's
Okay.
not required, and it's ordinarily not a public hearing.
Very good. Thanks for the clarification.
Sure, under the municipal land use law.
Very good. Understood. Okay, thank you.
Sure.
So I just reiterate, you will not have a chance to comment on our discussion of the consistency with the master plan tonight, but you're certainly welcome to stay and hear what is said and how it may fit in. And I encourage everyone to actually stay, and always like to see people at the planning board and get familiar with the processes and how it works, just for future reference, if nothing else. So thank you. Okay, moving on. First item on the agenda is we have two resolutions to memorialize past actions of the board. First one is PBO 624. Do you want to summarize that, Mr. Warner?
Certainly, Mr. Chairman, that was the Red Oaks School resolution in connection with the proposal to install facade signage on the school building. And the board will recall that the board ultimately unanimously approved that application. And also, there was a little bit of a miscommunication, I guess, by applicant's team, if I recall correctly, as to a certain additional sign, whether it was staying or going. And that was ultimately ironed out and clarified that indeed that sign was a permanent sign, was staying. There were numerous conditions of approval, including relative to the dimming of the lighting after certain hours, the hours between 10 p.m. and 6 a.m., and other conditions to mitigate any potential detriment to any neighbors. And hopefully the resolution accurately memorializes the board's unanimous decision to approve it.
Mr. Chairman, I'd like to make a motion that we accept this resolution as drafted.
Second.
May I make a comment?
Certainly.
Thank you. Mr. Chairman, on page 5, under item 13, number 2, it does indicate that the freestanding sign shall be removed. We in fact changed that.
We did.
So-
Later,
Yes.
if you read later.
Oh, I read, okay, I didn't read it. All right, I need to read more. So I second that we accepted this.
But
You
may I
second
want
the
to
second?
defend Board Member Murphy, that, probably in hindsight, rather than do it one way for the one day and then do the correction, we could have just gotten to the final conclusion ultimately,
Yeah,
so as to
yeah.
avoid any confusion, but
Thank you.
that's the.
I just wanted to make sure we didn't set something in
No,
place.
Linda, I
Okay.
did the same thing. I read it and I said, this isn't correct. And then I kept reading.
Got it.
Okay,
Thank you.
so it is
Yeah.
correct
It's correct.
as stated.
Yeah,
Okay.
it was perhaps too comprehensive. Took us what it was one day to the next day when it changed.
Okay, any other comments, questions? Okay, can you call the roll?
Mr. Alyssa,
Yes.
Ms. Van Order,
Yes.
Mr. Raddick,
Yes.
Ms. Murphy,
Yes.
Mr. Benoit,
Yes.
Mr. Flowers,
Yes.
Mr. Rivia,
Yes.
Mr. Pai.
Yes.
So moved.
Okay. Oops. Where's my- Oop. Oh, sorry. Okay, moving on to the second one for consider other resolution, PBO 724, the Madison Avenue Urban Renewal, AKA Restoration Hardware.
Yes, Mr. Chairman, happy to see that one up as well. The board will recall this was.
Did you all get this, by the way, today?
Yes.
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 It was emailed. Thank you,
Yes.
George. Thank you for signing for,
I didn't print it.
well, yeah, that's,
What was amended preliminary and final site plan approval and some proposed deviations from the requirements of the redevelopment plan for what we refer to colloquially, I don't know if that was, as the Abbey, and at 355 Madison Avenue. There are a lot of the deviations the board will recall related to certain amenities and features, which had been very specifically provided for in the redevelopment plan, and ultimately through certain iterations were no longer completely accurate as reflected in the redevelopment plan, and that I apologize for adding some judgment, but that probably resulted in a lot of the deviations being necessary from a technical standpoint. And it was a unanimous approval, 9-0 by the board, to make those changes. And as always, we had our fair share of conditions of approval there, and hopefully, as always, we accurately memorialized the decision of the board, as well as included all the conditions of approval to mitigate any potential detriments as a result of the approval.
Mr. Chairman, I'd like to make a motion that we approve the resolution as drafted.
Second.
any comments?
I have a question.
Yeah, go ahead.
For Mr. Warner, which is, can you perhaps just summarize the changes from the original? Because I have to confess that I didn't have time this afternoon to review this thoroughly, because I only received it in the middle of the afternoon, toward the latter part of the afternoon.
Certainly, and yeah, I don't, let's see, well, a couple of, I'll go through a few in no particular order or of magnitude, but the valet parking no longer was required to exist, given some reductions in the size of some of the footprints and some other changes with respect to the restaurant and the wine bar, as I recall, which alleviated the need for off-site parking of any type and the valet. And I think, well, I don't want, certainly that was a deviation that the board did not appear to have a significant problem with. Several others were some setbacks and perpendicular parking stalls, came into play, as well as a lot of features were eliminated or changed. The square footage of the restaurant and the wine bar changed. The square footage of the showrooms changed somewhat. There were a lot of features, canopies and trellises that were very specifically defined as to where they'd be located and different types of features, wall-mounted sconces and fountains and sculptures and water wall features and the like, climbing vines on trellises, on exterior walls, Mediterranean and similar species of fruit trees within the proposed restaurant as a means to create dappled shade, etc. It was a very specific and a wonderful, I think, redevelopment plan, but as often is the case, the ultimate project isn't an exact mirror of the original concept. So that, again, resulted naturally, in my opinion, of there being a fair number of deviations at this point in time. Heights of some pillars, number of identification signs. I think there were more directional signs added that may have been viewed as adding to safety and location identification. So hopefully that gives everybody a fair idea of what the deviations and the changes were.
I seem to remember that the new building is actually a little bit less tall. It's
Yes.
slightly shorter than it was originally proposed to be.
Correct. That's another. If I recall correctly, I think it's fair to say that a number of the deviations might have been things that were originally desired by maybe some members of the public and neighbors and the like. So
So I
Right,
recall,
that they were
some change
reduced.
is good change, perhaps, right?
yes.
Yeah.
Right. I remember liking it better than the original. So I just wanted to make sure that it was memorialized properly in here, and it seems to be. Thank you.
Sure, my pleasure.
Any other questions, comments? Okay, we have a motion. Could you vote, call the vote?
Mr. Alesso,
Yes.
Ms. Van Order,
Yes.
Mr. Flowers,
Yes.
Mr. Rabbit,
Yes.
Ms. Murphy,
Yes.
Mr. Benoit,
Yes.
Mr. Quillen,
Yes.
Ms. Bariglia,
Yes,
Mr. Vine,
Yes.
so moved.
So we have one application for public hearing tonight to move on to, before we move on to other matters. That's PBO 125. Do you want to introduce that, Sonia?
Yes, Mr. Chairman, this is PBO 1-25 CHC Madison Project Owner LLC for an amended site plan. This is block 8404, lot 6, 1 Cumberland Road in the OL5 zone. Applicant proposes the installation of string lights, outdoor speakers, and outdoor heaters for the use of the patio all year round.
Mr. Warner?
Certainly, Mr. Chairman, thank you. I did have an opportunity to review the notice for this hearing, found the content to be sufficient, found it to be timely served, certified mail on February 11, published on February 16, both at least 10 days, in fact, more than 10 days prior to this evening. So my opinion, the board does have jurisdiction based on the notice to hear and decide the application. And I'll swear in all the witnesses when appropriate, but I suspect, Mr. Chairman, you want to hear from applicant's counsel first.
Yes, let's,
Thank you.
please, go ahead.
Thank you. Good evening. Linda Hurley with Riker Danzig, representing the applicant this evening,
Really.
CHC Madison Project Owner LLC, which is the owner and operator of the Madison Hotel located on the property. As you will recall, the applicant was, before this board, received approval back in October to construct a patio at the northeast side of the building During that hearing, there were questions from the board and some discussion regarding lights, music, and use of the patio during the winter months, none of which was proposed by the applicant at that time. After the hearing and that approval, the applicant went back and there were some internal discussions and they've had a change of heart and would indeed like some greater flexibility in the use of the patio. So they're back before you this evening, seeking an amendment to the prior approval solely for the installation, as Sonia mentioned, string lights, speakers, and year-round use of the patio. The string lights are similar to what you may have in your backyard type of lighting. The same with the speakers. They're not professional speakers. They're typical backyard Bluetooth type speakers. And as far as the year-round use, there would be heaters, not permanent heaters as may have been originally indicated, but they would be portable heaters, again, as you may have in your backyard, that they would roll in and out as needed for use during the winter months. No other changes proposed to the patio and the landscaping that went along with it or goes along with it pursuant to the original approval. And no change to any zoning requirements or any of the bulk standards or anything else that was part of the original application. Michael Murray, the general manager of the hotel, is here this evening to testify, basically to tell you similar to what I just told you about what they'd like to do and why. And the landscape architect, or our landscape architect, Barry Yacker, is also here. If the board has any questions, I don't intend to call him up and ask him any questions. There really isn't much changing. You do have his plans, and he's added a couple of strings to show you where the string lights would be and a couple of locations of the 3 speakers, and that's really the only changes to his plans. But if you do have questions, he's here tonight to answer those.
Okay. Thanks, but you do have.
I do have,
Okay.
yes.
Why don't you bring him in? He can be sworn in, or
I'll swear them both in just in
Yes.
case any questions are answered, as well as our
And board
engineer and
professionals.
planner.
Right.
For our board, if all 4 of you will raise your right hand. Do, Mr. Hanson, do all of you swear to God or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you all. Back to you, Mr. Chairman.
Thank you.
okay.
Mike, if you would just remind the board of your,
Yes.
So originally we came in and.
I'm sorry, just a name and address, business address, fine for the record.
Name and address, Michael Murray, name, and the address is 1 Convent Road, the Madison Hotel.
And Mr. Early, he's testifying as a fact witness, correct?
correct.
No need to qualify. We're all fact witnesses by definition.
Okay.
Please proceed.
So during the last hearing, we spoke briefly about why we didn't add the speakers. So when I went back to the CEO, he goes, why didn't you add the speakers? Why didn't you add the string lights? So now I see you guys
I
again.
think we asked that question.
Yeah.
I remember making a very specific point about that.
Yeah.
And that's why we're here.
Okay. Are there any questions?
I
Yeah.
have one question. On Exhibit A that came to us, just for clarification, it references in the last sentence permanent outdoor heaters, although I just heard that they're portable. So they are in fact going to be portable, like we saw during COVID. They just kind of move around, right? Yep.
That's correct.
Okay.
The
So this is a-
propane one, like
Those are
outdoor
propane ones,
dining
correct.
kind of,
This
yeah. Right,
is a
right,
typo.
right.
Permanent is a typo on the Exhibit A.
Okay. Yes, Mr. Rabbit.
I've got a couple of questions, and welcome back, because this was completely predictable. On the string lights, any mitigation for the lighting to stop it from bleeding into the night sky, and in that regard? I mean, I'm familiar with string lights. They're usually the LED, the old Edison kind of bulbs that, but is there anything to keep it from bleeding into the night sky?
I mean, I think given the distance, the location of the patio
Mhm.
from the property lines and where it is behind the building, that I don't think it's
No
gonna.
problem. Another quick question on the speakers and speaker volume. We talked about Bluetooth speakers. Some of them can get pretty loud. I know, again, where the patio is located, that may or may not be an issue, but I mean, what are your plans for having parties, turn into, raves and, with loud music playing that would be just, disruptive to the neighbors?
So timing wise, for both the speakers and then with respect to the lights as well, they would be, an event, and certainly the speakers would be off by 10 p.m. And then we would ask that the lights may stay on till 11 if everything shuts down at 10, just to have the lights outside to clean up and break down whatever may have been going on. So from a timing perspective, noise wouldn't go, or the speakers wouldn't be on past 10 p.m. on any given evening. We would comply with the noise ordinance as we have to for anything that we do outside. And then I'll let Michael also discuss, when we were at the TCC meeting, the TCC had asked about having a noise study done after the speakers were in and when they were sort of up and running and there was an event. But I'll let Michael speak to what they do currently out there and what we'd like to propose as far as being able to measure the sound and prove that the speakers are at a level that doesn't exceed the standards.
So for the most part, what we host there is baby showers, birthdays, bar mitzvahs. So I don't know if we're gonna have too many raves. But the speakers are JBL, they're 45 watt. Automobile car has 50 watt speakers. We'll keep it at 65 decibels. I do have a decibel reader from our last reading in 2019, which we use around the property continuously every weekend. So we're adhering to the decibel law.
So what I heard then is that since you have that ability to measure the sound, that we can stipulate that they will measure sound during events to make sure that they're in compliance with the decibel levels that are in our ordinance?
Yes, a couple of things on that note. We did recommend all the board professionals a post-occupancy acoustical study demonstrating compliance with applicable noise standards. Our ordinance is consistent with the DEP's ordinance and regulations 7:29, 50 decibels in the evening maximum and 65 during the daytime. Evening is 10 p.m. to 7 a.m. if I recall correctly.
That's at the property line, right?
At the property line. And so they would have to be in compliance with that, as would anyone anyway. But this post-occupancy acoustical study that the applicant is stipulating to.
We just to be clear, what we'd like to do in lieu of having, I'll say an outside company come in with a decibel meter and do that, we'd like to use our own decibel meter with someone from the township there as we do it.
Excuse me. Our health director is certified for sound readings.
So that's our noise control officer.
Right.
Yeah. So if it's acceptable to our health director in his or her role, her role as noise control officer, to have someone else do it in her presence, I guess, fine. If not, maybe we leave it subject to the discretion of the health director to make that determination who does the measuring.
Whether she wants to do it or.
Correct.
Yes, that's fine with us. We were just in reading the TCC memo and prior discussions, we just wanted to clarify as opposed to having to engage an outside consultant to do it, that.
We have our noise control officer, correct, Dave?
Yeah.
And if I can add, we have at least 3 members of the board who live very close to your facility. I hear the weddings all the time. Happily, it's a joyous occasion, but I do hear it.
No one within 200 feet, though, as I understand.
I'm at least 500.
We do also have other conditions that were recommended, including a lights out timeframe for that.
But she said
10 o'clock.
speakers off by 10 and lights
By 11.
allowing 10, 11, allow cleanup and.
Perfect. Yeah,
Right.
that's what was written, so thank
Right.
you. Yes.
Just
Yes,
one
Ms.
quick
Wheeler.
question. So on the heaters, they're the tall, the heaters that you normally see outside. Is there a limit to what's the number of heaters that you plan to have? Or Chief, is there a standard of how many heaters?
All they
you
have
can-
to do is adhere to the obviously the manufacturer's specifications, and they're all subject to a fire code. So,
Okay, so you
they
don't,
can have 5 of them out there.
They can, but-
Obviously, That's going to become an issue.
right,
Too much stuff around. But that's
Right.
Totally within code.
do you know yet how many heaters? You don't
We do
know?
not.
Yeah.
Would the applicant stipulate, I'm stealing everybody's thunder, chief, I don't know if you'll let me, but our chief who's, did request that the applicant do what the applicant has to do by law anyway, which is comply with all manufacturer specs in accordance with the Uniform Fire Code, so I think the applicant will stipulate that.
Thank you.
Yeah, Mr. Coleman.
I have a question about the string lights. I think of string lights as being kind of omnidirectional. Are these lights going to just direct down toward the area where people are sitting, or are they going to spill over into other areas beyond the foliage? And I think I saw on the plan that the string lights will be mounted on poles that are 16 feet high. That seems very high to me, possibly higher than the vegetation. So is that the case?
Vegetation will be higher.
So,
Okay.
however,
If the answer is
if
later
the
witness.
answer's going to come from a witness, the witness will need to be
Introduce himself.
identified.
Yes, thank you.
He's already under oath.
Yeah. Just state your name and address, please, for the record.
Barry Yacker, 28K Dale Drive.
Could you speak into the microphone?
Can't hear you.
Mr. Reckon?
Barry Yacker.
Yacker.
So the address, business is fine.
Business is 36 Berkshire Valley Road, Kenville.
And why don't you, before you answer the question, give the board the benefit of your background, education, experience. I understood,
Oh, okay.
brand new application, so it's not, you don't carry over from last time, although they might remember you.
Okay. I'm a licensed landscape architect.
Microphone, yeah, thanks.
They can hear you, but not me. I'm a licensed landscape architect in New Jersey. Been practicing for over 20 years. Testified before, I was here before on this application.
License remains in good standing?
Yes.
And you were accepted by this board recently?
Then we will accept again.
With respect to the question of.
Okay, so the-
string lights on 16.
16-foot was just because of the sag and the, a little bit of a sag in the string lights. Does it need to be 16? We could bring it down a little bit, but your plant material, your arborvitae are going to grow thin and tall. They're going to eventually cover that. I forget what we put them in at. We put them in pretty decent size. And as far as the lights, as you know, with string lights, they provide light, not tremendous, so not like you're not going to read by it, but it's just to illuminate the whole area. It's in a zigzag, so it's not too many lights. We're trying to be conscious of what's going on in the outside.
And they tend to spill light in all directions, right? String lights send light in
Depends on
every
what kind you
direction.
get. Yes, generally they just have a small bulb on them, and yes, they spill out, but it's mainly a down track. Everything is within the planting area, so it should not, spill out on the other side of the arborvitae. The arborvitae are there to close everything in.
But even if it did spill out on the other side,
It's
of
not
the
gonna
parking
be
area
parking
of
lot.
the.
Right, it's in the parking area, and it's not gonna show very much.
Okay, thank you.
Any other questions? Any, okay. Then what? Oh, yes, this is a public hearing. Any questions of these witnesses by the public? Thank you.
Thanks. I thought you forgot about me.
I did for a minute, but thank you, Mr. Warner, for reminding.
Megan Burke, 8 Shepherd Place. So I've lived here since 2007, which is long enough to get Mr. Murray's crack when he came in that at least this was easy and that he wasn't proposing a dome. Anyway, so I came because I'm concerned about the noise and the lights. We live about a block and a half away from the back of the Madison Hotel. I live there with my husband and my 4 children. And we hear the noise from the events that are staged in the parking lot of the hotel from time to time. That noise travels to all of the backyards on Shepherd and even Barbary as well.
May I interrupt you?
Oh, thank you.
For a good reason, I promise, with the chair's permission. If you're not asking questions or only questions, but wish to make comment as well.
Do you want me to
with
wait?
the chair's permission, I could swear you in. That way you can make comment as testimonial oath.
Sure, sorry, maybe I jumped the gun.
No problem. But you can also ask questions as well.
Okay.
So if you'll raise your right hand, you swear to God or affirm that the testimony you're about to give and that which you have already given is the truth, the whole truth, and nothing but the truth.
I do.
Thank you very much. Please continue.
So anyway, so the noise does travel to our yards, and that's our concern with regard to the patio the speakers being added to the patio and also the lighting. I can hear the noise from the games at FDU. So thinking that noise is going to travel, especially in the evening, from the patio in the backyard, in the back of the hotel is not a stretch for us. So I've listened here tonight. I understand that you're willing to stipulate that the noise will shut down at 10. To me, that's still late, right? This is a change from what we're used to. And you are still somewhat newer owners, in my opinion, at the hotel. But this is a neighborhood that is a very old neighborhood. It's a very close neighborhood, and you happen to have bought a establishment that's in the middle of a very nice residential neighborhood. And so you need to be mindful of your neighbors. And this I consider is something that's going to have a real impact on us. It's unclear to me. I mean, they just came back for a second bite at the apple, which I found disappointing. Everybody on this board, I'm a town volunteer myself. We spend a lot of time, and they now have to hear this application all over again. And so I don't know what would stop you from coming back again and saying, well, actually, we would like to extend our liquor license to the back patio. There's potential for cigarette smoke, marijuana smoke that's going to float right down the block into all of our backyards. That's why you have an outdoor patio. You don't have an outdoor patio to do what you represented at the previous meeting, which was to have, businesses and clients have a place to go outside in the back, right? You're doing it to make money. So I would just appreciate it if everyone, would be honest with us. Those are my main concerns. I'd ask the board to take that into consideration. The other thing is that as a member of EDAC, we spent the last few years putting together the Madison Avenue Corridor Study, which some of the members of the planning board are certainly familiar with. I was part of that. That was presented to the Township Committee. I believe referred to the planning board to be included as part of the master plan reexamination. I went back and read that document again before I came here tonight, and there was nothing in there that suggested to me it was something that the residences or the businesses had in mind when we were thinking about what we wanted to see along the Madison Avenue corridor. It certainly wasn't what I see eventually down the road what this patio could become. So thank you. I think that basically covers my concerns. Thanks.
Thank you. Any other?
I think we can take questions or comments.
Yeah, questions. Yeah, questions or comments since. Okay, seeing none, I guess we will close that portion. But is there any response to that? To those concerns? And some of it is just like, I guess it's not really scope creep, but creep in the actual use and activity of what might be there.
Understood. And while I wasn't here at the last hearing, Mr. Rasiopi was, but I think even from the board members' responses tonight, that it was certainly, what we're asking for is certainly something that you were anticipating. They may have said they wanted to do at the last hearing, that it wasn't outside of the scope of possibility for the patio. And while they hadn't originally proposed it, and they stuck to what they thought, what their original application was, we've said it just, it was a change of heart afterward. The use of the patio that isn't changing. as far as the activities that are going to be out there, and the applicants represented what those activities are going to be. And I think that they're entitled to the benefit of the testimony under oath and the representation to you as to what it's going to be, and whether there's to use the speakers, for example, whether there are speakers there. We still have to comply with the noise level, whether it's just speakers or whether it's a group of people, gathered for an event. So that's.
Quick question. What is the intended use of the speakers? I mean, is it like for just ambient music or public address kind of, DJ?
It's solely for ambient music.
Okay.
That's all it's for.
So there won't be a, microphone, public, address system connected to them?
No.
And would the applicant stipulate to that as a condition of approval if the board were to approve this application and would be of a mindset to accept such a condition? In other words, ambient music, no amplified music, I guess, or band, I don't know.
Well, it is
No
amplified.
live
right?
music.
No live music.
Right, okay, right.
I believe you said 45 watts,
Each speaker is 45 watts.
45 watts. How many speakers? Like just off
Three
top-
speakers.
Three.
No. Okay.
Is there ambient music only, no live music, correct? Is that a condition the applicant would stipulate to if that's so desired by the board?
If we were to have live music, it wouldn't be hooked up to the speakers.
Okay, so no ambient music or live music, acoustic, not amplified. Is that something, yeah?
Yeah, in other words, they don't want to condition away what they would otherwise be permitted to do by way of live music, but they're not going to hook this up, they're not going to put a band and hook them up into the three.
Bob Dylan's not going electric. Okay. I got it.
Yes, he is. Too late.
I know. I think the applicant just stipulated to that.
Okay.
Mr.
Chairman?
I'm sorry.
The resident has a good point, because the evergreens probably will not attenuate the sound very much. Is there any other sound attenuation you could put in there to block the sound, so that it does a better job than just letting it float out? Some sort of screen or,
I don't understand what you said. Sorry.
well, some sort of sound screening. For example, like, at Madison Avenue, they put a whole different, I'm not saying you should do this. They put a whole row of bushes who's designed to prevent the sound from going through. So maybe there is some sort of sound wall or something that you can put up that would not be ugly. You want to have it look good for your customers, but maybe there's more that you can do than just turn down the sound, because I hear the music from over there too. It just hasn't bothered me, but I don't live on Sherman. I live on the other side by North Oak. Shepherd, thank you. So I don't know, could there be any consideration to other ways to attenuate the sound?
And I'm sorry, Barry Yacker speaking now, correct, for the record?
We'll just switch it. No plant material is going to eliminate sound completely. It helps deaden sound. These speakers were selected, they're ground level speakers. There are other plants around these speakers in that courtyard. So the sound is going to be deadened. Is it going to be totally gone? No. That all depends on the levels that they're set at. There's not, we kept the areas kind of tight, so it's kind of limited to how much more plant material you can put in there. So I'm not sure, what you're saying is,
Just point of clarification, I'm familiar, I think all of us are familiar with ground level speakers. What will be you could put some sound deadening, let's say mulch, as opposed to rock, which will tend to reflect sound, but mulch will tend to absorb it.
Right.
What would be around the speakers?
They're in the beds, in the mulch beds.
In the mulch
So-
beds.
So they are within mulch, they are within ground cover coming around them. So, I mean, when we designed it, we did take that into consideration. If they were going to put speakers in, we wanted to keep, low density speakers aimed in, ambient music. It's in the back of the building, so it's.
Thank you.
Mr. Chairman?
Mr. Chairman?
Yeah.
Yeah. I'm imagining, and I just want to get a clarification, I don't know if this could be a stipulation, but if I'm out there in this patio area, I may be with other people talking, so I'm not really looking for loud music around me. I'm just looking for that kind of sense that it's not, that I'm in a social environment. So that's what I'm imagining, this, not like the music isn't the purpose of this space. Okay, just confirming that.
Mr. Chairman,
Yes.
I'd just like to point out that they are agreeing to conform to the noise ordinances as well. So that's going to make sure that at the property line, you're not going to have a lot of loud music or noise other than the normal conversation and ambient music that they're
Right.
talking about.
Any comments, questions? Yes.
If we're getting close to a point of deliberation, I thought it might be appropriate just to remind the board exactly what we're voting on and what I understand the standard for this modification or excision of conditions to be, and applicant's counsel can weigh in if she concurs.
Okay, I think we are at that point,
Okay,
so
then,
please proceed.
Again, the applicant effectively is asking for the modification, if not elimination, in part, if not whole, of two conditions of approval of the prior approval from our prior resolution. One, no exterior lighting or audio speaker systems shall be installed within the proposed patio area. That obviously would be changing. And the proposed patio area shall not be used during the winter. That obviously would be changing as a result of this proposed application. The standard for modifying previously imposed conditions, various standards, they may become unreasonable through changed circumstances or may be revealed as unnecessary and may be reconsidered by boards in later years. Also, our courts have held that boards have the power to modify or eliminate prior approval conditions upon a, quote, proper showing of changed circumstances or other good cause warranting modification or amendment, or where enforcement of the restrictions would frustrate an appropriate purpose. And specific to the good, those are disjunctive or, so either of those standards. With respect to what would constitute good cause, our courts have held that the board's intent in imposing the condition in the first place should be considered, and whether the proposal to modify or eliminate the condition is consistent with or contrary to that intent. That may relate to some of the input provided by the board during the process of the hearing with respect to original intent and expectations, perhaps, when the approval was first granted and those conditions were imposed. Like most legal standards, it says what it says, but it says so much. It's subject to interpretation, but I wanted the board, assuming there's no objection to that standard from the Cox Book and the applicable case law, including Cone v. Fairlawn and Allied Realty versus Upper Saddle River from applicant's counsel, that would be the standard for the board to utilize in determining whether or not to eliminate and or modify the conditions accordingly. I do have conditions of approval that if it is a grant of approval, the applicant did stipulate to the lights being turned off no later than 11 p.m., the speakers being turned off no later than 10 p.m., a post-occupancy acoustical study, involving our noise control officer, AKA health director, as well as the heaters being portable and the noise, the music being ambient music or live music, but not amplified live music, if I understood correctly. And after that, it's up to the board. Majority for passage if it's a motion to grant with all those conditions.
Mr. Chairman, I make a motion, we approve the applicant's changes as enumerated tonight and delineated in Mr. Warner's list of stipulations.
I second.
She has a question.
I wanted to make a statement, which is I'm not inclined to agree to this because I think that this is a little too much of a creep, a little too soon. I know that the original approval was last year, so that modification is in a new year, but I'm worried about some of the things that may happen. I think the look of this change may be unattractive. I think there will be people out at night in an area where there aren't people now at night very often. And there may be live music played, which will be a big change for the neighborhood. So for those reasons, I'm not in favor of approving it. So I wanted to say that.
Any other comments from the board? Guess none. I guess we could proceed with the vote. We had a public comment already, so. Anything before from the attorney, from the applicant?
I don't have anything further.
Okay.
Thank you.
Okay, proceed with the roll call vote.
Yes.
It's in order.
Yes.
Mr. Nunn,
Yes.
Mr. Rabbit,
Completely predictable, yes.
Ms. Murphy,
Yes.
Mr. Benoit,
Yes.
Mr. Quillen,
No.
Mr. Rivia,
Yes.
Mr. Bott.
Yes.
So moved. Thank you.
Thank you.
Okay. Moving on to other matters. The first one on the list is the possible removal of the tree removal replacement deed restriction that was placed on PBO 0121. Joseph Savage is in for minor site plan approval for subdivision 34 Starlight Drive. Understand this came from the engineer's office?
Came from Jim.
Okay.
Before he left. The reason for the request for a change is it doesn't need to be a deed restriction because each house on this property is going to have to come in for a grading permit. The grading permit is going to indicate what trees have to be taken down on each lot. And that's going to be based on what they're proposing to build versus what was shown on the subdivision as a potential building. And with that, we require a tree removal permit to be part of the grading permit on newly formed lots. See, right now, all subdivisions, whether they occur this year, last year, 2 years ago, when they get developed, even 10 years ago, we just had one on Fox Hollow. We held them to the tree removal permit requirements, and they had to plant trees to replace the trees that they had removed to build the house. To have that as a deed restriction, we're still going to go through the same work task, whether it's in the deed or it's just part of our normal protocol when we look at the plans and the grading permits for the previously made lots, part of the subdivision. So I think it's just asking the same thing twice.
Okay, because
I don't think it's needed in
I think I wasn't present at the hearing, but I did review the
I don't
videotape
think it's needed in the deed.
because I believe the concern was because at the time they said that, they wouldn't be able to, they couldn't specify where the replacement trees would go or how would they deal with the replacement plan because of the grading issues, and they may be different from what is out. So I believe there was concern because the trees that are shown on the plan, they have a replacement plan, but as were DEP requirements to fill in with the tennis court, and that only accounts for like 14 or something of the 145 that are supposedly under ordinance that they're required to supply.
Right.
So you're saying that even after the subdivision of those lots are sold, because I guess my concern would be once the lots are sold and separated, then they're not considered homestead lots.
Right.
And so that they still are, the tree replacement requirements go with the land in that case?
There was a subdivision on Fox Hollow that occurred when I first came here back in 2007. They only built the house there last year or the year before, and we held them to the tree removal requirements.
Okay.
Only because what was proposed in 2007 and what was proposed now was a box versus an architectural house.
Yeah, right.
And it took up more area, plus they cleared to allow for a swimming pool in the next year or two. So we held them to the requirements, and we're currently holding a bond waiting for this spring to come around for them to finish planting the trees.
Okay, so if we remove this as a deed restriction, the property owners, whoever they may be, and I see they're listed for sale now, those two lots, they will be held to the requirements of the subdivision
Right.
tree replacement, removal and reform. Okay. Any other questions?
Mr. Chairman, I'm
Yeah.
a little confused. They're coming and asking for a time extension?
No.
Actually,
No.
That's another matter.
Yeah, different. Yeah, I'm with, if I may, Mr. Chairman, I had the same confusion, Mr. Lesso.
Did I go out of
Board
order?
Member Lesso, because this came in today. And I believe it is, I was just reading it to make sure, I believe it is a separate, that just so
Oh, geez.
happens that they're getting close to the subdivision recordation deadline and asked for this, and I was actually going to see if, I think it might be a little late for us to consider it. 11:59 PM, might be, so to speak, tonight. So that, it is, I think, different, but gives you the benefit of the resolution there, and you can see the conditions, and it's condition 5 on page 14, that
Oh, I
they're
didn't see that.
effectively asking to be eliminated.
Okay. So I guess I never
May
saw
I
that.
ask, what does it matter to them? What's the disadvantage to them of having it remain in the deed?
I don't know. It takes, there's an awful lot that's going to have to be put in this deed with regard to easements and that type of thing between the township and them. Cross easements or common driveway easements. To add another deed restriction in there that they have to follow the tree removal permit seems like a moot point because they're going to be held to it anyway.
May I just clarify, is this a request from the applicant or from our office?
Our
office.
Yes, Jim did not believe that it was required to have the tree removal requirements in the resolution because it's already covered in the grading permit requirements.
Is there harm in having it in the resolution?
No.
Are the actions the same? The actions are the
Sounds
same.
like it, right?
With 8 things in it instead of 7 things in it or 9 things in it, might not make a whole.
It doesn't seem to make any difference.
Right.
Would it make any difference to you folks in the engineering office if
No, because we're
you have to,
doing it anyway.
you'd be reviewing it anyways? And all the other deed restrictions and things in there, you also have to pay attention to anyway, so it'd just be part of the package.
Yeah, there's a bunch of easements in there that are going to have deeds drawn on them and that's so it doesn't matter.
So I would say just leave it.
It would just be us. We're going to look at it anyway.
Mr. Chairman?
Yes.
Again, maybe ask Mr. Warner for advice as to how to proceed? Because it sounds like we really don't need to do anything, and I'm not sure if that's the only thing we're being asked to look at, and then move this along.
Well, to the extent I haven't shared it, and for that matter, Mr. Hanson may have concurred. Our engineer suggested it be eliminated, and it may not make a big difference one way or the other, perhaps to anybody, including the applicant. It wasn't a request by the applicant, but our engineer requested it. If the answer is it doesn't matter one way or the other, then the answer is you can decide either way, and in my opinion, it would be a defensible decision.
So is that all we're being asked for as part of this? And then there's a
That's it.
second,
Yeah, it's just
then
a
there's
removal
second
of that
ask
one
for the
condition.
extension? The extension
Number
already
5,
passed.
page 14.
Well, the extension, I think, Sandra, is the extension on for tonight? You literally
No, I,
literally got it this afternoon.
I distributed
This
it
evening.
because they're running out of time.
When are they running out of time?
But they ran out of time.
They already ran out of time.
Already
It's the
ran out of
25th.
It's
Yeah, they-
not pro tunc, it's after the fact. They can ask for an extension after
Oh,
the
maybe that's
fact.
not it.
They don't need notice to ask for that
Maybe, I don't know.
extension. So if the board wishes to avail themselves of the opportunity right now to decide one way or the other whether they get that extension, we could certainly follow up with a resolution memorializing the extension, if you give them one. It would be, I haven't had a chance to even read it, let alone do the math. What are they asking for?
when did it come?
Extension to August 19th,
Another 190 on top of the 190, and what would that bring us to? So,
August 19th.
Well, their 190 days expired February 25th of this year.
February 25th?
Yes.
All right. So 190 days from February 25th. If you wish to grant it, that request, you can do so. And then we could,
there it is.
you could also let me know if you want me to put in that resolution that we're eliminating condition 5 or we're not.
Mr. Chairman, can I try to make a motion?
I didn't get, I'm not aware of this extension that was asked for. That's
It
what I.
literally came to us this evening.
It was on our desk when we walked in.
It's
We
the
have
Oh,
last-
okay, okay, I'm sorry. Okay,
So-
okay.
so
It's
last
not the
page.
bottom
Can I
of
have a
my
motion?
pile. Sure.
I'd like to make a motion that we leave the tree requirement we leave the deed restriction as is, and we grant 190 day extension.
Ms. Murphy.
My comment is that the delay was due to DEP. The applicant wasn't able to meet the criteria because he had New Jersey DEP permitting issues. So I would agree that giving him an extension makes perfect sense. It wasn't his fault that he couldn't apply.
Is that a second?
That's a second.
And thank you, Board Member Murphy, because I didn't give the standard, but you certainly remember the standard. It's, barred or delayed as a result of this, effectively a third party, not something under your own sole control, so.
Okay, we have a motion and a second. Any discussion?
Roll call?
Yep, roll call.
Wait,
I'm sorry, Mr. Khalid.
So I believe so this motion involves two things, and I think I can vote on one but not the other. So
Oh, that's right. Yeah, so we should,
Thank you,
oh,
Board Member. I'm going to respectfully request that rather than split it up, because it's kind of hard to do, on one resolution, Board Member Bai qualified himself by watching in the entirety of the prior hearing. I don't believe was the case for Board Member Quillen. So if you don't mind, participating was fine, but maybe we could have 8 board members vote.
that's fine with me.
Alessa?
Yes.
Ms. Van Ora?
Yes.
Mr. Nunn?
Yes?
Mr. Rabbit?
Yes.
Ms. Murphy?
Yes.
Mr. Benoit?
Yes.
Mr. Biglia?
yes,
And Mr. Vine?
yes.
2, 3, 4, 5, 6, 7, 8, 9.
Can I count Mr. Flowers? Mr. Flowers?
No?
Yes, you voted on the original. Okay.
Okay. Okay, moving on to the next other matter, which is amending the ordinance, review for master plan consistency of ordinance 0125. That tree protection requirements ordinance. That's
And I
before us.
earlier gave a reminder to the board and everyone as to how this works. So with respect to all four of these, the person we don't want to hear from is Mr. Phelps, to my right. I won't hold this up any longer.
Thank you.
Yes, Mr. Phillips, please.
So I'm going to preference some comments which will apply to all four of the ordinances that we're going to address for master plan consistency.
Okay.
Just to provide a framework. So the master plan, let me back up. The municipal land use law in addressing the planning board referral powers requires the board to identify inconsistencies between a proposed regulation and the master plan. So again, the standard is not that the proposed regulation is consistent with the master plan, but whether or not it is inconsistent with the master plan. And you're all nodding your head because you've been through this nuanced language with me before, but I wanted to basically provide that framework so that everyone on the board kind of understands what the requirement is, and that'll provide, I think, some understanding of what I'm going to recommend to the board on the issue of master plan consistency. So having said that, the first ordinance, which the chairman cited, would amend the existing tree protection requirements which are set forth in chapter 57, which is our land development ordinance. And the key changes are that the ordinance would now sort of partially, as opposed to wholly, exempt homestead lots. And this is being done to comply with NJDEP requirements. And you'll see that if you look at the ordinance itself, there is a qualification on the exception of homestead lots, again, to be consistent with NJDEP with regard to tree removal. It also specifically provides for an escrow contribution to a tree replacement fund for those applicants who don't totally provide the replacement on site. And lastly, what it adds is a provision for penalties for any illegal tree removal. Those are the three changes relative to the existing ordinance. Let me provide some historical master plan perspective, because I think on this one it's important. So back in 2007, there was master plan. This is before my time. And that master plan made a specific recommendation that the homestead exemption be removed. Okay, that was in 2007. And when I was the planner in the township, both the board and the governing body were considering a comprehensive change to the tree removal and replacement ordinance. And it went through a lot of discussion with this board, and the governing body ultimately tabled it in 2013. So when we did the master plan reexamination in 2017, knowing that it was tabled at the time, the board basically made a recommendation that it was now no longer going to recommend that the homestead lot exemption be removed. So it's sort of come full circle. So in my opinion, the bottom line is I don't believe that this ordinance change is inconsistent with the master plan, because it now basically seeks a partial exemption only to comply with the NJDEP. And clearly, in my mind, it meets the spirit and intent of the ordinance. So
Mr. Chairman, I was there when all this went
of the
down.
master plan. I'm sorry. Thank you for correcting.
I have the history here. The issue with the homestead lots centered around owner property rights. And I think that's why it got kind of contentious about how can you deny the property owner the right to take action on their own property.
And also enforcement.
And enforcement
That
is still,
that's a major
enforcement
issue.
is actually still an issue, I think, because we're providing for no more than 8 trees
Right.
removed in a 5-year period. But the question is, how would you ever monitor that? It's gonna have to be based on complaints. That would be the only way we would probably even know. The same would apply to removal of dead and diseased trees. You know, someone may make a complaint, we'll go check it out and say, yeah, that tree was gonna fall down anyway. So, it does give a nod to the concern that tabled this issue all those years ago, which was ownership, property rights. So, from that perspective.
And Steve said to me, I think it's consistent with the spirit and intent of the master plan,
Right.
not the development regulation.
Well, I would agree with that in that although they removed that specific recommendation to remove the homestead exemption, the established, it left in a primary policy goal of encouraging homeowners to preserve trees and replace trees.
That's still.
That's still in there.
That's still
So,
in the master plan,
right, that's still there.
still
So,
in the master plan.
so it is not inconsistent with.
And really, that
triple
change
negative.
is basically driven by having to comply with NJDEP.
Right.
That's really the basis for that change to the homestead lot with that qualifying language on exemption. The 8 trees, no more than 8 trees in the 5-year period. So I'm recommending to you that this is not inconsistent with the master plan.
And if I may, with respect to all 4 of these ordinances, as previously we always do, we have a one-page, we can do a one-page resolution. It provides for a finding of not inconsistent, but it has the word not in brackets. We do not attempt to influence any decision. We can either take the word not out for any or all of these, or keep the word not in for any or all of these. So it's an easy enough adjustment to make so that you can not only make your determination, but also go right to adopting a resolution this evening for each. So that's what we have for the tree ordinance 1, of course, as well.
Mr. Chairman, I have a question.
Yeah,
on the
Mr.
ordinance. It's not clear, it says cutting, and someplace else it says pruning. So if you need to prune your tree limb that's dead, so it doesn't fall down on your electrical wires, is that included in this? That's exempt.
That's under exemptions.
For the homestead lot exemption.
That's the exemptions.
Number 4.
Number 4, right. So the distinction pruning versus cutting, that's what that is.
Well, it says pruning or removal then.
On or over a public right-of-way or public property by an appropriate authority. So if you're a private homeowner,
So that would be
You
public
can you,
works.
can you prune the tree because,
Absolutely. This doesn't affect you.
Okay. okay,
These are all
Nor does the
exemptions.
existing ordinance.
right. I didn't think so,
These are all exemptions.
right, but this is public.
What?
Pruning
If
over a
and when the
public right
board
away or
is
public
ready,
property.
they can
By
vote
an appropriate
on
authority.
a resolution
Yes.
I
to find this ordinance not inconsistent with the master plan
So
or the advice of our planner, if that is your.
If it
I
was-
would entertain a motion to.
I'll make that motion.
I'll second it.
Quick question,
Yes.
we do each one separate?
Yes.
Yeah.
Yeah,
But that-
Right.
with the key over public.
I second.
Any more discussion? This is a roll call vote too, I believe. So Sonia?
Ellis?
Yes.
Ellis? Ms. Van Horn?
Yes.
Mr. Nunn?
Yes.
Mr. Rabbit?
Yes.
Ms. Murphy?
Yes.
Mr. Benoit?
yes.
Mr. Quillen?
Yes.
Ms. Correia?
Yes.
Mr. Ty?
Yes.
So moved.
Okay. Next on the list is the consideration of ordinance 0225, amending chapter 57, land development, code of for master plan consistency. And that's, which one is that? That's the,
That prevents them.
okay, this is, yes, this is, okay, right. Again, site plan exemptions, right,
So this,
right.
this one involves changes to the existing site plan exception provision in, this also is in the land development ordinance, which is chapter 57. And essentially, we've had a number of issues that have come before the TCC. And I mean, the bottom line is that the existing provisions are somewhat confusing. somewhat discretionary, which they shouldn't be. And in some cases, we think they're actually onerous, the way currently written. So this amendment would provide clarifying language, and it would specifically exempt things such as roof-mounted solar equipment, which we've had this discussion here before this board. We thought that would be a good idea. Any, for example, electrical vehicle charging equipment as part of an existing development would not have to come to this board. Conforming wall signs is something that we don't think it's kind of onerous to ask someone to come to this board. They would be specifically exempt. And so, as you might expect, the master plan, which is dealing with more macro issues, is completely silent on site plan exceptions. So for that reason, I'm basically recommending to you that this ordinance would not be inconsistent with the master plan, again, if adopted.
Can we make a motion?
Mr. Chairman.
Yeah.
Mr. Chairman, can I make a motion that we accept this amendment or this ordinance, and it is not inconsistent with the master plan?
I'll second.
I have a question for Mr. Hanson, engineering. Is this something that you would support? It's just, I mean, it's more, I mean, this is the kind of thing you guys deal with all the time with permit applications, right? Is this,
Red Oak School sign.
right,
Should never have
In
been.
a desktop administrative approval.
right, okay.
Where it
right.
should have been.
That's- Yeah, okay.
I can assure you, Jim was all over.
Yeah, well, I asked the question, pretty much sure I knew what the answer was.
We've sat in on some of those, but
Yeah, well,
We could call this the Jim Slate resolution.
okay, we have a motion and a second.
Mr. Alessa?
yes.
Mr. Order?
Yes.
Mr. Nunn?
Yes.
Mr. Rabbit?
Yes.
Ms. Murphy?
Yes.
Mr. Benoit?
Yes.
Mr. Quillen?
Yes.
Mr. Rivera?
Yes.
Mr. Fine?
Yes.
So moved.
Okay, moving on. Next is consideration of the ordinance 0425, which seeks to change the zoning
Yeah.
to remove a little jog in there.
Yeah, so this ordinance would actually modify through a zone map change, the boundaries for a particular lot 3105, lot 6. This property is presently occupied by a main residence, and there's also a carriage house on the property. The applicant basically is looking to subdivide off the carriage house. And the interesting thing is that the properties on either side of the carriage house are presently located in the RA 11 zone. The bulk of this property, almost all of it, is located in RA 25. And if you look at the zoning map, it kind of, I think what happened is the zoning map followed property boundaries, which is not inappropriate per se. But this little jog is the only property along the frontage, I think it's Conklin.
Conklin, right?
Where the RA 25 extends down to Conklin. Everything on either side for a little bit of a stretch is RA 11. So we thought, the TCC thought this was a good thing. It allows the subdivision to create two lots to keep the main house subdivided off the carriage house. So the best way to do this was part of a zone change that would allow, again, two lots. The carriage house would be in RA 11, and then the main residence would be in RA 25. The issue here is, technically speaking, this change is not consistent with the master plan, because the master plan land use element map, which goes all the way back to 1994, clearly follows the zoning map and shows what we would propose to be the R11 portion in RA 25. Even though it's a good thing, it's not consistent with the master plan. And I think the decision, the TCC took the position that to attempt to do a sort of a master plan amendment for this small property was probably not within the cards. So really what it means, if you agree with me that it's not consistent, is that the governing body will, when they consider it, they'll have to do something called a reasons resolution, which requires them to state reasons why they're doing this because it's inconsistent with the master plan.
Notwithstanding that, it's.
Right.
It's
And
not too-
also, it requires a majority of the full authorized membership of the governing body. So again, even though this is a good thing, you have to call it the way it is. It's not, in my opinion, consistent with the master plan.
So we're gonna, if we approve it, we're gonna approve it notwithstanding it not, it is being inconsistent.
No, we would be saying it's
You're gonna
inconsistent.
recommend to the governing body that it is inconsistent,
Right, okay,
which will force them to do the reasons.
got it, yes.
Right.
And that's a resolution to
That's a
say,
resolution,
okay.
By resolution per the MLU.
At the governing body level.
Mhm.
So the alternative, as you said, would be to do a master plan amendment for this little thing.
One little tiny.
And is it possible for them to subdivide that lot without?
If they subdivided, correct me if I'm wrong, Paul, but if they subdivided, they would be creating a
They have all
nonconformity.
kinds of variants.
Yeah.
They would need D variances on the whole, yeah, okay, right, which should be, yeah.
Perhaps the prevailing thought is that this is the most prudent way of addressing it without overkill.
That was the prevailing thought.
Yeah, right.
So then
You know, I
both,
always like to say perhaps, I don't want.
then both the remaining structures will be on lots that don't require variances?
Yeah, once subdivided, the RA25 zone portion would be conforming with the bulk requirements, including minimum lot size of RA25. That's the way this was set up.
That makes sense.
In the R11, the carriage house
That would
is
also-
also be conforming in the R11, yes, right, right.
I guess
yeah.
in a way, this two-step process cleans it up,
Mhm.
right?
Yeah, it's a weird lot because it spans from Egbert Hill to Conklin. And so there, it's not like there's a long driveway that gets to the back of it. It actually has an entrance onto existing street, so.
That house predates everything in that area.
Yeah. right.
So they just built the subdivision on Concord around
Around it.
that other house. Yeah.
So,
So if the board wishes to follow the recommendation of our planner, it would be a motion to adopt the resolution finding the proposed ordinance to be inconsistent
right.
with the township master plan.
Yes, we should do that.
I'll move that.
For a second.
Second, Joe Alesso.
Okay, we can call the roll on that.
Mr. Alessa?
Yes.
Ms. Van Order?
Yes.
Mr. Nunn?
Yes.
Mr. Travis?
Yes.
Ms. Martin?
Yes.
Mr. Benoit?
Yes.
Ms. Wellings?
Yes.
Mr. Reglia?
Yes.
Mr. Kai?
Yes.
So moved.
Okay, moving on to the consideration of ordinance 0825 concerning the designation, the overlay zone for the cannabis overlay zone. Mr.
So,
Phillips.
Yeah, so this ordinance is being advanced in conjunction with a companion, if you will, and more sort of comprehensive general ordinance amendment being advanced by the governing body, which would ultimately regulate cannabis businesses in the township. And that general ordinance includes a lot of things that are not typically included in the zoning ordinance, things with regard to financing, licensing, all that stuff. This is just basically, this ordinance would provide for a cannabis business overlay zone within a portion of the township's I-21 district along the Ridgedale Avenue corridor. And what the zoning would do, it would establish standards for various classes of cannabis businesses within that overlay district. So with regard to master plan consistency. So the last master plan we did was in 2017, and I asked rhetorically, do you think there's any mention in 2017 in the master plan about cannabis? Predates the state legislature. There's nothing. There's absolutely nothing on cannabis. So, I mean, in its pure form, you can take the position that it's not inconsistent with the master plan because there's no mention of cannabis. But there are two other factors here, which I think are sort of the board should take into consideration if it were to agree that this ordinance is not inconsistent with the master plan. And I think number one is that this zoning overlay would not propose any changes in the underlying I-21 zone district in terms of the use regulations, the bulk regulations. It would simply allow for an additional development alternative within the district, subject to its own series of standards, which is set forth in the ordinance. So you're not changing I-21. You're sort of adding another use within I-21. Okay. The other thing that I found interesting was that actually the 2007 master plan did affirmatively recommend that this portion, this Ridgedale Avenue portion of the I-21 zone, basically from Hanover Avenue to the Morristown border, be reviewed to take a look at this to determine whether or not any other uses, and it says including retail, interestingly, would be appropriate. I think the planning board, if you recall, the people on the board at the time were looking at the corridor, understanding that there were changes, understanding that uses other than industrial might make sense, knowing that there were some long-term uses that might not necessarily be in the best interest of this sort of future land use pattern in this area. It did make that particular recommendation. So with those caveats, I'm sort of recommending to this board that this overlay ordinance would not be inconsistent with the master plan.
Yeah, I would concur and add that, yeah, I looked, I couldn't find any reference, not unexpectedly couldn't find any reference to cannabis either, but under goal 4, which I think is where the kind of the examination you said, it does also leave in there as a goal, or added the 2017, is analyze the township's major arterials and commercial corridors to assess current conditions and evaluate whether existing zoning is adequate and determine what improvements are needed. So this is certainly not inconsistent with that statement.
And Mr. Chairman, as I pointed out, even more so here, there's a specific recommendation with regard to Ridgedale, this portion of the I-21 district along Ridgedale Avenue, specifically to look at it, whether other uses may or may not be appropriate, including retail.
Any comments?
I just have a question. The Morristown border is right at the railroad track, right?
Yeah, pretty much, yes.
So from the railroad track up to Hanover was
Correct, more or less,
we're talking about.
Yeah. The map is on the back there. A map is on it. It's not very good, but it's, but you kind of follow it.
Joe? I noticed that you talked about distances from schools and distances from residential. If residential is built in a neighboring town, does it have an impact? Or is it residential in Morris Township and the schools in Morris Township?
I believe the way it is worded, it does not discriminate between where the school is.
And the same thing with residential?
Correct.
So the apartments that are by the brick,
Masonry.
whatever's going on with that brick situation, like going to the showroom or something, that would push, if someone were to do one of these 5 or 6 uses, they would have to push deeper into the zone to stay out of that 500 square.
On which side, I just want to make sure to
That's
answer
Morristown.
this.
It's Morristown.
Which side?
That's Morristown. Yeah, it's in
But the
Morristown.
question is.
Oh, I see what you're saying, yeah.
Residents.
Because there's a distinction here, that's why I want to get your answer correct. The project you're talking about is that the east or west side of
West side of Ridgedale's 500.
Okay, then it would be subject to this if it's on the west side of Ridgedale.
And if the office building on the other side of Hanover gets converted into residential before someone were to apply for one of these uses, that would also affect them in the opposite direction.
Are you talking about across the Morris Township border
Yes.
into Hanover?
Yeah.
Yes.
Okay. I'm just trying to understand how that zone could get crushed.
I think the point of the standard is that the standard should apply no matter where the school or residential zones, whether it's in Hanover, Morris, or somewhere else. That's the standard. You're trying to protect public health, safety, welfare.
I think they use the term sensitive receptors. It's a term utilized as an umbrella for houses of worship, residential schools, etc.
Also, it's Monday, so I'm a little punchy. The standard here is that we're to. Agree
Your microphone is off.
Not inconsistent with the master plan. That's what we're being asked.
Correct.
Not inconsistent.
Correct.
And you're suggesting that it's not inconsistent.
That is what I'm advising you, but again, it's the board's decision.
Based on the silence, as well as the two additional reasons that Paul gave that would move it from even silent to maybe towards even more consistency.
So it's our job to basically agree or disagree with you.
More or less, yes.
And that is actually essentially the scope of your jurisdiction.
I'm prepared to make a motion.
I just have a question.
Yeah.
What if there's a facility that's built, a cannabis facility, and someone proposes to build housing within that 300 feet or 200 feet? Do we have to deny that? Say it's low-income housing, but do we have to deny that because there's a cannabis facility there?
No. Because
Sequentially.
it's sequential.
The sequence matters.
Have been
Okay.
set, and again, the standard is not for the residents, the
Yeah.
standard is for the cannabis business.
Okay, thank you.
I had a, maybe, okay. No, I had a quick question that says it's not within 500 feet of a residential zone, I believe. Is that all, and that's for things west of Ridgedale? That's not just single family, does that include, because there's,
Any residential.
so part of the RH,
We're not
and
discriminating,
and there are
protecting
some,
residents, whether they live in an apartment complex.
and there are some that at least have the multifamily overlay zones on there also, right? Does that count?
That's on, they're all, I believe. on the east.
Oh, they're on the east side, okay, right. I guess that section along Hanover is not, that doesn't have those overlay zones, okay.
Right. Here's the
We're
highway.
not endorsing
No.
the use. What
Nope.
we're doing is we're
Whether it's
endorsing the
consistent,
fact that it's consistent.
whether it's
with the
inconsistent with that, that's your charge.
That's your only as I
Right.
explained
You're not
much earlier this
endorsing,
evening.
you're not-
Whether it should be done or not, it's
You don't-
up to
You
these
don't have
folks
that
on the
authority or
19th.
jurisdiction.
Yeah.
That's
You're
it.
not voting in favor
Policy-
of it, you're just the master plan.
You're the gatekeeper of the master plan, you don't make policy.
So
in
if it's
that
okay
regard.
with the chairman, I'd like to make a motion that we pass this resolution, that this overlay is not inconsistent with the master plan.
I'll second that.
Any more discussion?
Mr. Raleigh,
It's
Yes.
not a public.
Ms. Reynolds,
Yes.
Mr. Nutt,
Yes.
Mr. Ravish,
Not inconsistent? Yes.
Ms. Murphy,
Yes.
Mr. Benoit,
Yes.
Mr. Quinn,
Yes.
Mr. Ridley,
Yes.
Mr. Bond.
Yes. Okay. Do we have anything from the legislative committee report point of view?
Nothing I can think of.
Nothing pressing.
Okay, we do have on the agenda, there is an opportunity for public comment, so they should be limited traditionally to things that are not agenda items. So if you have anything other, any members of the public want to comment on other items, please come forward, state your name and address.
Pam Russell, 31 Lower Lane. On the 500-foot buffer zone for next to residential zone that is in the cannabis ordinance, why is that limited to west of Ridgedale Avenue in the ordinance? Why doesn't that apply to the whole township?
Well, it's a question that best asked on the 19th.
Well, you were just discussing it.
Of the governing
But I
body.
think-
I think the board's questions with respect to the ordinance were relative to trying to determine the consistency or inconsistency with the master plan and what the history was. As far as explanations
Well,
of the
this sounds like a
ordinance,
question for the planner, right? I mean, is there a 500-foot buffer zone for residential, for cannabis businesses next to a residential zone for the entire township?
It only applies to within the overlay zone, because that's the only place that could be, according to the ordinance, the only place that a business could exist is in this overlay zone. So it only
Well, you
applies.
say, in the other provision of the, you say a cannabis business cannot be in a residential zone, correct? But you say that for the entire township, right?
Let me,
But so
maybe-
why is the 500-foot buffer zone limited to west of Ridgedale Avenue, which doesn't cover most of the township?
excellent questions for the governing body and the planner at the March 19th public hearing, when the issue is not simply whether or not it's consistent with the master plan, which is all this board has allowed on its referral.
Okay,
With its
so
referral
is
already
this public
being-
comment? Okay,
Yeah, bear with me. Thank you. Their referral obligation has already been completed, but these questions certainly would be pertinent on the 19th, when the governing body, a different body, has a public hearing on the application. And I suspect might have the same planner here at that time, in that capacity.
I don't think there's a
that's
planner
allowed.
to the township committee. There's just a planner to the planning board, right?
He's-
Okay,
he's
well,
planner
is it-
for the planning board this evening.
Okay, so I would like to voice my public opinion that having cannabis businesses next to a residential zone with no buffer zone is not consistent with the master plan. And I think most people in the town will agree with that when they realize what you have just all approved. Thank you.
Hi, Lori Georgian, Two Spring Valley. So again, going to the master plan, I was at the last meeting and it was talking about the area that you're talking about actually just being a retailer. But
I'm sorry, if I may, just so, and I'm sorry, I didn't get your name.
Lori Georgian,
Thank you.
Sure.
Ms. Georgia.
Two Spring Valley Road.
Thank you. When you say you were at the last meeting, the last planning board meeting?
February, public meeting, when they were approved.
She's talking about the township committee.
That's what I thought. Yeah,
Sure.
this is not the township.
No,
committee.
I know, but there's a lot of people on the township committee and the
That-
cannabis advisory board. I'm just making a comment.
Right.
It said public comment, so
Right.
I'm
That
here.
Just, if you had any questions or concerns, or those policy issues.
I'm getting to, yeah, hang
Would be
on.
addressed by the
Yes.
appropriate board.
Sure.
You might recognize faces. This is not the governing body.
That's
as
fine.
you-
I'm actually
as you
talking
know.
about ordinance number 8-25, which you just commented on. So
Right.
if you give me a chance to finish,
It's a
that would
red-
be great.
I
So
will-
under
I
that,
will. So you
section D,
understand.
number 14, I just would like comment
Yeah.
on that. That's
Yeah.
it, Steve.
Right, and it's my job to represent this planning board,
Sure.
not the governing body, and to make it clear what the scope of their authority is and what it isn't. And if you, I suspect you will want to come back.
Oh, I
for
will
the
be back, yes,
Appropriate
of course.
board, the governing,
Yes.
entity, the governing body, and make your comments and questions, et cetera. But with the chair's permission, and the understanding that this is not their authority,
Completely agree.
Feel
Yeah,
free.
it's just a public comment, kind of what I stated that I was coming up for.
with the chair's permission, it's not improper legally, even though the board is not addressing these issues.
Correct.
Yeah, go
Yeah.
ahead.
It's under the ordinance that you were just talking about, the master plan. So I guess my concern is when it was initially discussed that it was going to be a retail. Now I see there's 6 different classifications, cultivating as being one of them. I think someone brought up at the last meeting, were you planning on growing weed? And it was no, we were not. So I guess my concern is, why is that a class that's in here that's being put forward?
And that is a question that we can't
Correct.
ask.
Yep, I'm just
Right?
making public comment.
can't ask
So hopefully, everyone, whoever's listening, will come back and understand that there are 6 different classifications that are being put forward by the township, not just a retailer. You're looking for delivery drivers, you're looking for cultivating, you're looking for retailing. There's 6 different classifications. So we need everyone's support who has joined on Zoom and listening today to show up and speak up. That's it. Thank you.
I wasn't planning on, I don't have a voice, so I really wasn't planning on talking at all. But my name is Patty Esposito, 11 Brandywine Terrace.
11 what?
Brandywine Terrace. The only comment I really wanted to make was I know that you were just discussing about if it's consistent with the master plan or not. And I mean, on a whole, it's not consistent with the master plan because the master plan prior to now didn't mention cannabis in it at all. So you're saying you just voted that it's not, that it is consistent with the master plan,
No,
or that it's not consistent?
it's not inconsistent.
It's not inconsistent with the master plan, because by exclusion of not having that word in the master plan, you're saying it's not inconsistent, which is a play on words to me, because I feel like it is inconsistent with the master plan, because the master plan did not talk about cannabis. Understand it because cannabis wasn't an issue because it wasn't approved. It wasn't. So now I feel like you just voted it's not inconsistent when it is inconsistent. So I'm really surprised that you turned the words around like that and voted the way you did when it really is inconsistent. Don't wave me away. He just waved.
He was talking to me. I was going to address when you're done.
Okay, well, so that's what I feel like happened here. It kind of feels like it was a play on words, and you guys played around with it and said, yeah, it's not inconsistent. But in real life, it wouldn't be, because cannabis wasn't in our world then as an approved substance or approved anything. So that bothered me today. The other thing I just wanted to comment on is this is a planning board, and then there's a governing board, right?
Governing body, the township.
All right, a governing body. So there's people on the planning board here that are also on the governing body?
Correct.
How many?
Bud and I.
So that doesn't seem right to me either.
Well, that's municipal land use law.
Yeah,
It
that's a law.
requires, zoning boards have no governing body members, and they are completely quasi judicial, like the court system, but quasi because we're administrative. But planning boards by law, on the municipal land use law state statute, requires that planning boards have one member who is either the mayor or the mayor's designee, oftentimes the mayor. So that may be one governing body member. And then also requires a class 3 members, not a class system in the old sense, but a class, they call them class 1, 2, 3, 1, 2, 3, 4 members. That's a class 1 member is the mayor or mayor's designee. Class 3 is a governing body member. So by law, planning boards will have at least one, if not usually 2 members of the governing body. They must have them on there, as well as a municipal official who's not a governing body member, class 2, and the rest of the members, class 4, cannot be.
So they can vote on both? They can vote in
They wear
both?
2 different hats in that respect. And planning boards hear applications for development that are in their quasi judicial role. And they also do other things like, I always use the phrase gatekeepers of the master plan. They generally handle things like master plan consistencies, reviews. So not only is it permitted, but by law, state law, but it is required by state law. So just so everybody's clear, no matter what anybody thinks, we may disagree with the law. This is how it is required to be.
It just doesn't seem like they can vote on both personally. One should be abstained, but it's kind of like directing the results.
The legislature, not even the governing body here, of course, when they are here, but the state legislature would be the one to change that.
Okay, I understand. So the 2 governing body people on the planning board here that just heard that you passed, that it's not inconsistent to the master plan, I feel like it is inconsistent to the master plan, so I just wanted you to know that. Thank you.
Any other comments from the public? Oh, okay, thank you. I guess we'll
I make a
close.
motion to adjourn.
You didn't give me a chance to close the public comments. You're quick. Okay, now.
I make a motion to adjourn.
Is there a second? Second. All in favor?
Aye.
All, aye.
Thank you all for coming.
Yes, thank you very
Thank
much.
you.